So friends, welcome to the 85th session of Legal Empowerment Through Interaction Lecture Series. Every day we have been meeting without fail for the last 84 days, afternoon 3:30. We have been exposed to different thoughts, ideas. At times we had disputes, differences, but all of which only augmented our knowledge or through interaction we have been empowering ourselves. Yesterday we had dug the ruins at Chambal Valley to find out different temples which were resurrected. Today we'll do the same thing, though not in ruins, but of ideas and thoughts which are far ahead of the time. At that point of time, were not properly appreciated, but later they shine like daffodils. I mean, the topic itself says so. And we have got a wonderful faculty today who is a part and parcel of this platform. All of you are well aware of him, Advocate S.K. Premraj Menon. He'll be dealing with the subject, and introducing the subject will be by our own Professor Dr. Kaul. And today we are privileged by the presence of Justice V. Ramkumar, Justice Basant, Justice Roshan Dalvi, Justice Shalini Joshi, and all of you wonderful participants who have been here throughout. So let us make this session really interactive and wonderful. Over to you, Kaul sir, for the introduction of the topic.
Well, I think I'm very happy to be part of you today, because I want to listen to this subject very closely, because it's very close to my heart. Yesterday when you talked to me about introducing this subject, I exactly did not know what you wanted me to do, but I thought it was a very good topic, and I should look at it. I think two important observations which I would like, which have been made and have been, in fact, often repeated by the Supreme Court of India also in number of the judgments, are the observations of Justice Charles Evan Hughes, who became the Chief Justice of United States of America. But when he made these observations, he was a member of the New York Court of Appeals, and he delivered 6 lectures in Columbia University. And in the second lecture, he made certain very prophetic observations, I think, that have come true in India also. He said, a dissent in a court of law, last resort, is an appeal to the brooding spirit of law, to the intelligence of a future day, when a later decision may probably correct the errors into which the dissenting judge believes the court to have been betrayed. And then there is Justice Scalia, former associate judge of the Supreme Court, who said, when history demonstrates that one of the court's decision has been a truly horrendous mistake, it is comforting to look back and realize that at least some of the justices saw the danger clearly and gave voice, often eloquent voice, to their concern. You know, when Indian Constitution came into force, immediately thereafter, we had one of the most celebrated cases at that time was A.K. Gopalan's case. And this is the beginning of the period of the Supreme Court being a technocratic court. Because I think we have to see the Supreme Court at least in 2 periods. One is the court before Maneka Gandhi, or at least we can say when Cooper's decision, R.C. Cooper's decision came in. That was a technocratic court, literal interpretation of the Constitution of India. And then we find subsequently a proactive court of the Supreme Court of India, where they moved away from the technocratic approach and resorted to proactive approach. But during the technocratic approach also, that period we had some judges who had a vision. And three cases which have been referred to by Justice Nariman in his judgment in Justice Puttaswamy's case are A.K. Gopalan and the dissent given by Justice Fazl Ali in that judgment, Senior Fazl Ali. When the majority was reading the fundamental rights in a watertight compartment, and Justice Fazl Ali in his dissenting note, judgment, did not see that Constitution of India, at least the fundamental rights need to be read and should not be read in a watertight compartment. They must be read together. It is not exclusion of one from the other. And the challenge in that case was to the preventive detention law. And Mr. Gopalan's two arguments was one was about Article 21 and second was Article 19(1)(d). And the majority did not, read them together and said 21 and 19(1) cover two exclusory, areas. And therefore, that argument was not accepted. But Justice Fazl Ali's judgment later on, we find R.C. Cooper and Maneka Gandhi realizing the vision of this judge. And you find that Supreme Court saying that these fundamental rights have to be read together. It's not that one is read in exclusion to the other. Similarly, when we go to Kharak Singh's case, we find Justice Subbarao echoing the same sentiment, who was a true champion of the personal liberty. In fact, when I accepted the invitation of Mr. Sham to introduce this topic, I had in my mind one of his most celebrated judgment was Mayor Hens George versus the state of Maharashtra, where he gave a dissenting judgment relating to interpretation of the FERA, Section 8 of the FERA. And it was a seasoned smuggler who was on trial, who was found to be having 34 kgs of gold in his, pockets. And the question before the court was interpretation of Section 8 of the Foreign Exchange Regulations Act. And the question was that the section was mens rea neutral, and whether the court could read it as strict liability offense. And Justice Subbarao, in the minority opinion, said civil liberties of the people, personal liberty of the people is at stake. Therefore, you cannot, on the slippery ground of the welfare measures of the state, read it as a strict liability offense. And he was not ready to read Foreign Exchange Regulations Act as a strict liability offense. But in 1966, he became the Chief Justice of India, and there was a case called Nathulal, and that came under the Essential Commodities Act 19, that came, and then Justice Subbarao, again, dealing with Section 7 of the Essential Commodities Act, was not prepared to exclude mens rea and read mens rea into that. And therefore, that judgment, to undo that judgment, the legislature intervened. They made an amendment in the law, and subsequently, the change was made in the Essential Commodities Act by bringing exclusion by express words in the statute. So that is where I said the approach of the judge was basically, in the Kharak Singh case, the question was about privacy, whether right to privacy is a fundamental right or it is only a common law right. And Justice Subbarao, in the dissenting judgment, which ultimately becomes the majority, becomes the main law when we see Justice Puttaswamy's judgment, that Supreme Court recalling in that judgment, each judge referring to Justice Subbarao's dissent in Kharak Singh's case. And finally, the dissent of Justice Khanna in ADM Jabalpur. And that cost him the Chief Justiceship of the country. And the majority judgment reading right to life as the sole repository in Article 21, while Justice Khanna was not prepared to read it only in Article 21. He said it is something which is inherent in a person who is born as a human being. And I think this area is a very, very important area, and we must celebrate these three opinions and other opinions which have over the period of time told us that courts need to have a vision, judges need to have a vision, and that vision makes the Constitution of India a dynamic and a living a document which will not only serve the past or present, but should serve the future also, and should in fact deal with all the aspirations and needs of the people at large over the period of time. I think with these introductory remarks, I can pass it on to the main speaker of the day. Thank you very much.
Thank you, Dr. Professor Kaul. Today, before we start the presentation by Prem, I would like all of you to know that it would be under the watchful eyes of his mother as well that the presentation would be happening. We welcome you, ma'am, to this platform. Thank you very much for joining us. Over to you, Prem. All yours, Prem.
Well, good afternoon, everybody.
Good afternoon.
I'm really delighted to see Justice Roshan Dalvi, Justice Shalini, Justice Basant, Justice Ramkumar, Dr. Kaul, and in particular, my mother too, who is watching me. Firstly, I have been advised to confine myself to 2 or 3 major dissents. But I would just invite the comments from the partakers of this talk to know if you want me to set any limits on the scope of the talk by confining myself to these 3 major rulings, or do you want me to run through a couple of more significant dissents? I think I would go a bit ahead of not more than 3, I think so. So kindly bear with me. At the outset, I need to remind myself that talking to the judges and lawyers regarding dissent, that is akin to taking owls to Athens. As we all know that the inhabitants of Athens, they are already being thought to have sufficient wisdom, or rather maybe selling snow to the Eskimos. In our legal fraternity, the courtroom, even though we all treat it as a holy place, there is nothing which is inviolable, as no persona is so lofty that he or she cannot crack, crumble, or collapse. No character is so pure that it cannot be simply torn apart or ripped apart. There is no such repute which is so unassailable that it cannot be torpedoed out and pulverized. And trust me that there is no idea which is so holy that it cannot be deferred from. Now, just prior to dealing with this dissenting judgments, I would like to invite your attention to the words of Justice Rohinton Nariman in the famous case Shreya Singhal versus Union of India, 2015, 5 SEC, page 1. As we know, Shreya Singhal case, that was the case where the Supreme Court struck down Section 66A of the Information Technology Act of 2000, which really related to the restrictions on online speech as unconstitutional, on the ground that it violates the freedom of speech which is guaranteed under Article 19(1)A of the Constitution. The court went on to say that this is not a reasonable restriction on the freedom of speech as has been encapsulated or rather dealt with under Article 19, Clause 2. And inter alia, the Keralites would know that Section 118 of the Kerala Police Act of 2011, that also was struck down as unconstitutional. Section 118 of the Police Act that dealt with the penalty for causing grave violation of public order or danger by either by statements or by verbal or telephone calls or whatever, chasing or sending messages or mails, etc., which was punishable for a term of imprisonment up to 3 years or with fine, which is not exceeding 10,000 or with both. According to Justice Nariman, when he spoke for the bench, he said that 66A was cast so widely that virtually any opinion on the subject would be covered by it, as any serious opinion which would dissent with the modes of the day would be caught within its net. And such reach of the section, if it was to withstand the test of constitutionality, then it would have a very chilling effect on the free speech. So that was one of the most wonderful statements which was made with regard to the right of your free speech, that too by the Supreme Court. As Professor Kaul has taken you to the famous words, a dissent in a court of law, in a court of the last resort, is an appeal to the brooding spirit of law, to the intelligence of a future day, when a later decision may possibly correct the error into which the dissenting justice believes the court to have been betrayed. So said Charles Evans Hughes. He was the 11th Chief Justice of the United States Supreme Court, and that was made during his second lecture at the Columbia University. And please see that this locus classicus, it was quoted with much approval by two of the finest and most scholarly judges of the Supreme Court of India. The first one being Justice H.R. Khanna in the famous ADM Jabalpur case, and subsequently by Justice R.F. Nariman in the Justice K.A. Puttaswamy case, while overruling ADM Jabalpur. John Stuart Mill, who was a social and political theorist, he once presented a scenario in his essay on liberty. He went on to say that if all the mankind minus one were of one opinion, and only one person were of the contrary opinion, mankind would be no more justified in silencing that one person than he, if he had the power, would be justified in silencing the mankind. If everyone in the whole world minus one, they shared the same opinion about something, we can only imagine how reviled the opinion of the single outlier would be. Surely such a deviance would be explained as something what you can term as wretchedness, and doubtlessly the possessor of such an aberrant belief would be the object of scorn or ridicule. So why should one antagonist be allowed to ruin the otherwise unanimous confidence which is shared by everyone else? That would merely come into our thought. Now, Mill would argue that perish such thought, exactly the opposite should occur. Now, the lone dissent, that must have the protection of the state, either on his or her side. The one voice in a million that is audacious enough to declare all the other 99,000 miles are mistaken, that the lone voice, it must be protected from the mob, that would eagerly silence it. Now, naturally, you may be reminded of a talk which we had recently in our own platform. Miss Suchita Subramaniam's talk on this platform we had a couple of days back. And one need to realize that over himself, over his body and mind, the individual himself is a sovereign. A selectively bestowed liberty, that is no liberty at all. And yet there is another moral peril also in silencing the lone dissent, like squelching and silencing a person's freedom of expression, that not only robs the individual of his or her right to speak, but it really robs everyone else of the right, privilege, and opportunity to another point of view. And the peculiar evil of silencing the expression of an opinion is that it is robbing the entire human race, the posterity as well as the existing generation, those who dissent from the opinion, still more than those who may really hold it. If the opinion is right, they are deprived of the opportunity of exchanging the error for truth. And if it is wrong, of course, they would stand to lose what is almost what you can call as a great benefit. So the clear perception and the livelier impression of truth, which is produced by its collision with error. So therefore, any agitator's idea, any heretical idea, any non-conformist idea, that all plays a very vital role in the society. If somebody demands that your view should not be expressed, then what is to be concluded is that that person's view is infallible. Isn't it like that? But I have to conclude that the other people, they should not be allowed to think about the idea for themselves. Now, again, as we all know, there is another great speaker on this platform, Justice Nagamuthu, one of the finest legal briefs I have come across. Now, he never compels anyone to attest to his views. And he always used to say, see here, everybody has the right to hold to your own views. So he never thrusts upon you any of his views. Now, I should also mention that we have had speakers who had tried to thrust their views on the audience, and even some of the partakers also who comment that the speaker is thoroughly wrong. I'm not taking out any names. We need to realize that one should not offend the speaker's right to speak and the audience right to hear. And what are today's crazy ideas, which is held by a very, very tiny minority, that could easily become the mainstream ideas of tomorrow. We don't know. We are not sure about it. And that being the case, it would be both morally wrong and practically foolish to suppress the minority opinions, no matter how offensive most people may find them. So please let us not be blind of the fact that our history, it is positively littered with great examples of marginalized ideas that eventually formed part of settled consensus. The three of the cases which were dealt with by Professor Dr. Kaul. Even from the history we could see in the epic Mahabharata, when Draupadi, she yelled for help, the great acharyas, they remained silent. Kindly see India's history. When the invaders took into India, we looked away. During the emergency time and all, for quite a long time, when our rights were suspended, people just spoke with muffled voices. When innocents, they were butchered in the name of religion. We see that even in the post-independence era as well as in the pre-independence era, we thought of revenge. And each of these silences, I would say, has cost us more than the lives. And these silences cost us the time and threw us decades behind where we should have been right now. And whenever there were dissenting voices, we really left them alone to fight. For we thought that dissenters, they are inherently loners. They are lonely enough as they do not fear the loss of power or money or fame, whatever that be. But trust me, as has been said by Justice Dhananjay Chandrachud in a recent speech which he has delivered, a couple of months back. Now, the dissent means that is the very foundation of the democracy on which we build our comfortable villas. It is the power of dissent that keeps the nation afloat. And Justice Chandrachud went on to term the dissent as a safety valve of democracy. He went on to add that the blanket labeling of dissent as anti-national or anti-democratic strikes at the heart of the country's commitment to protect the constitutional values and promote deliberative democracy. So we need to realize that a separate view that is so strikingly different from the majority, that is the very hallmark of a vibrant democracy and an independent judiciary. The Indian Constitution that guarantees to every citizen the right to freedom of speech and expression, as we see in Article 19(1)(a). And this freedom includes the liberty to freely express one's views, opinions, and thoughts, whether that be in writing or in speaking. So, broadly, if you think over or ponder what exactly is 19(1)(a), you would get the idea that this particular right that also includes the right to think and organize your thoughts without any kind of inhibitions, of course, subject to 19(2), or any kind of external mandates or coercion. It means of not being influenced by some other external views and holding that a view is completely one's own. Therefore, this would call the very need to discuss the relevance of the right to freedom of speech and expression and the dissenting judgments on the very touchstone of democracy, as has been there in the preamble of our constitution itself. The dissenting judgments are the decisions which are rendered by one or more of a particular court who disagree with the majority opinion, and therefore they are free to express their own views in relation to the case where they depart from the majority opinion of the bench. This may be adopted or may not be adopted owing to the facts and circumstances of each and every case. And further, with such a dissent, the dissenter judge at least is able to clarify his or her stance with regard to the case and why a different view needs to be adopted. And needless to say, that is dissenting judgment that paves way for a different approach or solution to a very particular dispute, initiating the discussion, at least in the society. And nevertheless, it is at this juncture very important to profoundly at least dwell into the relevance and rationale of the dissenting judgments, as I said, on the very touchstone of our democracy. Historically, the very roots of dissenting opinions that can be predominantly that you could find in the common law countries. Common law countries, they began to publish the dissenting opinions for improved judicial administration. And it is evidently seen in the systems of common law, which have seeped into our Indian judiciary as well, at the very grassroots level, after the advent of the British rule in our country. The origin of the dissenting opinions can be traced from the judicial dissents, right from the Supreme Court of Calcutta, which we first had, the first Supreme Court which we had in terms of the Regulating Act of 1773. Then you had dissents in other presidency courts, the other two Supreme Courts which we had, one at Bombay and the other at Madras. Then we had judicial dissents in the federal court. You had the judicial dissents. And now we know, after the Constitution being enacted on the 26th of January 1950, the federal court gives way to the Supreme Court of India. And as was practiced by the federal court, the trend of writing and publishing seriatim opinions, if need be so, that has become the ritual in the apex court as well. Now, some of the classic judgments which I would deal with in my talk, that would illustrate how the learned judges, they have expounded the nuances of law and expressed themselves unconstrained by the need to persuade their adversary judges, and the extremely brilliant contrast to the majority views to open the very shades of justice, pointing out those vital facets on which the majority missed their mark. And the judgments which I would deal with are the ones which have really appealed to my thoughts. And I am, of course, I am cognizant to the fact that there may be other judgments also. There are other dissents too. Now, the ends of the Constitution, as we all know, is justice, liberty, equality, and fraternity. Because they reinforce our constitutional values. So, being so, weren't those majority opinions evil, one can think, if the dissenters, if the dissenting voices later on became law? Weren't those majority opinions evil as opposing to the very Constitution, which really I would say it plots with the will of the people as being an antithesis of our Constitution's goals? And we won't see dissenting judgments in the Privy Council till 1966, because the Privy Council judgments, they were really advices to the monarch, and they never had a single dissent, for the reason that the Judicial Committee could only give a unanimous opinion with no differing voices, because it should be conducive to much clarity, because the king or the queen, they have to pronounce a judgment. So it should be conducive to clarity. And subsequently, it was in accord with an order passed by King Charles I during 1627. And we had occasions where one of the great judge, it is in the biography of Chief Justice Gajendra Gadkar, it has been written that one of the greatest judges, Justice M.R. Jaikar, who was a judge of the federal court and who was also a judge of the Privy Council, he had to write a judgment even though he had an entirely different view. Because in the Privy Council, only one person could pen the judgment. So Justice Jaikar, who sat along with three other Britishmen in a case where he held an exactly opposite view of the other three judges, Justice Jaikar was made to pen the judgment even though he had a different view. And now from 1966, we have the Judicial Committee dissenting opinions order, which now permits the dissenting opinions in the Privy Council. Now I would go straight to the topic. Article 21 of our Constitution, as we know, which is said to be not merely a twinkling star in the high heavens to be worshipped and rendered vociferous lip service only, but it is indeed an actually meaningful protective provision. And as Dr. Kaul put it, this was one of the articles which was considered by the Apex Court, a 6-judge bench of the Apex Court in A.K. Gopalan versus State of Madras, AER 1950, Supreme Court, page 27, where it was a case of habeas corpus dealing with the Preventive Detention Act of 1950. And inter alia, the reach of Article 21 also was deliberated at great length by the 6-judge bench. The majority that was headed by Chief Justice Kania, propounding the doctrine of directness of legislature, because it was propounding that doctrine, it took a very narrow view. The majority took a very, very narrow view, holding that Article 21 had absolutely no relationship either with Articles 14 and 19, and observing that personal liberty that has nothing to do with the rights under Article 19, which talks about a different set of liberty, and either Article 14, which speaks of reasonableness, that had no relationship with Article 21. And the majority virtually made a liberal interpretation of the words procedure established by law, which is appearing in Article 21. Now, voicing against 5 of his brother judges, Justice Said Fazil Ali, the lone dissenter in that judgment, he meaningfully examined and interpreted the fundamental rights, broadly construing the provision, procedure established by law in Article 21, holding to encompass higher principles of natural law and justice, and not just the statutory law as held by the majority. Justice Fazil Ali went on to hold that the Indian Constitution intended to incorporate the same language as the relatively new Japanese Constitution of 1946 and encompass due process of law conception. He cited various foreign precedents to support a much more expanded view of the due process principle. And he went on to hold that the principles of natural justice is a part of the general law of the land and were required to be read into Article 21. Now, the majority goes on to say that, see, this is a preventive detention law, and what is said is procedure established by law, which differs from due process of law. Because due process of law is separate, procedure is separate. Procedure means it's a set of procedure which controls. And see, we have the preventive detention law by itself is it lays down a procedure. So Article 22 by itself was a watertight compartment. So it can only, you cannot span it over all the articles. Article 22 by itself is a watertight compartment. So let that be seen. This was during 1950. And mind you, 20 years thereafter, the majority view which held the field for 20 years and which of course led to anomalous results also, that was clarified in R.C. Cooper versus Union of India, AER 1970, Supreme Court 564, which we know as the bank nationalization case, in which the constitutionality of the banking company's acquisition of transfer of undertakings Act of 69 was under challenge. And it was before a bench of 11 judges of the Apex Court. Now, they quashed that legislation as being violative of Articles 14, 19, and 31 of the Constitution, upholding the minority view which was expressed by Justice Said Fazil Ali in A.K. Gopalan's case, which view went on to be reiterated 8 years thereafter in Maneka Gandhi's case, AIR 1978 Supreme Court 597, by a bench of 7 judges, spelling out that the procedure prescribed by law that has to be fair, just, and reasonable, and it should never be fanciful, oppressive, or arbitrary. Now, the second judgment of Justice Fazil Ali was in Ramesh Thapar versus State of Madras, AR 1950 Supreme Court 124, which was one of the most important cases on free speech, where the constitutionality of Section 9 of the Madras Maintenance of Public Order Act of 1949 was under challenge before the Supreme Court. Now, this particular section allowed the state government, for the purpose of securing public safety and maintaining the public order, to control and regulate the entry and circulation of any set of documents, which of course was primarily the newspapers in the state. Now, the Supreme Court had to clarify the meanings of the terms public order, public safety, and undermines the security of the state. It defines public order as a state of tranquility which prevails among the members of the political society. And on technical grounds, it was found that public safety meant, in that context, the very same thing. And the third one, undermining the security of the state, which we have in Article 19, Clause 2. It meant nothing less than endangering the foundations of the state or threatening its order. So hence there was a clear difference in the degrees between these two clauses. The court also would cite the fact that the word sedition, which we in Article 13(2) of the draft constitution we had, that was deleted and it was replaced by the formulation of Article 19(2) and the narrow definition of the sedition, which we see in the Privy Council judgment, King Emperor versus Sadashiv Narayan Balrao, AER 1947, Privy Council, page 82, that implied that there were very narrow and stringent limits which were enunciated in Article 19, Clause 2, as the freedom of speech lay at the very foundation of all the democratic organizations. And without a free political discussion, no public education. So essentially, for the proper functioning of the very process of any popular government, it is possible. And thus, it went on to hold that Section 9 of the Madras Maintenance of the Public Order Act that used the broader phrase, that is phrase public order, which was unconstitutional. Now again, Justice Fazal Ali dissented. And the reasons of this dissent, you can see only in the judgment. The same year, there was another judgment dealing with another same like case, Brijbhushan versus State of Delhi, AER 1950, Supreme Court 129, where the issue was one and the same. There, it was one which concerned Section 7(1)(c) of the East Punjab Public Safety Act of 1949, which allowed the pre-publication scrutiny of material which is prejudicial to the public safety or the maintenance of the public order. So essentially, the pre-censorship, it was for one other challenge. Now, the majority followed the decision and reasoning in Ramesh Thapa, which I said first. And Justice Fazal Ali dissenting, he held that public order, public safety, sedition, and undermining the security of the state essentially amounted to the very same thing. Now, applying a somewhat convoluted logic, he goes on to hold that because sedition undermines the very security of the state, usually through the medium of public disorder, and therefore it is difficult to hold that public disorder or disturbance of public tranquility, they are not matters which undermine the security of the state. Now you see, the very first amendment to our constitution, the words undermines the security of or tends to overthrow the state. It was replaced by the words in the interest of public order. In the interest of public order. Just because of this particular two dissents by Justice Fazal Ali. So now you can see the three dissents by Justice Fazal Ali becomes law. And another great dissent of this great judge is the case of Keshavan Madhav Menon was the State of Bombay, AER 1951, Supreme Court, page 128, where the prosecution under the Press Emergency Powers Act of 1931, that was under challenge. And the core issue, it was whether sections 15(1) and 18(1), read with the definitions which are contained in sections 2, I think it was 2(6) and 2(10) of this particular 31 Act, which was inconsistent with Article 19(1)(a), and assuming that they were inconsistent, whether the proceedings which were commenced under Section 18 of that particular Act before the Constitution was commenced, that could be proceeded with. Now that was the question, and the majority held that the prosecution could be proceeded with. But see the minority judgment of Justice Fazil Ali, he dissented, holding that by operation of Article 13(1) of the Constitution, the law which is in conflict with the fundamental rights was never a good law of 26th of January 1950, and the prosecution cannot continue as a law which made the act an offence has by itself become completely ineffectual and nugatory. And Justice B.K. Mukherjee, who was a party to the judgment, who also was a signatory to the judgment, he agrees to this particular view. Now, the second greatest dissenter is Justice Subbarao, K. Subbarao, a legendary dissenter. One of his greatest dissent was in Radheshyam Khare's case, Radheshyam Khare versus State of Madhya Pradesh, AR 1959, Supreme Court, page 107. Now, the question which arose in that case was the nature of powers of the state government to supersede the committee of a municipality, and whether it was necessary to give the hearing to the committee before superseding it, even though when there was the Central Provinces and the Berar Municipalities Act of 1922, which did not provide for affording such an opportunity. And that opportunity, whether it was never obligatory under that particular statute. So they held that merely because a statute required a government to pass a recent order, it did not mean to record a judgment which is judicially arrived at, though they recognized that an order of supersession that cannot cast a slur upon the committee or its members. Justice Subbarao, he took a contrary view. He dissented from that. He went on to say that, see, the duty to act judicially, that may not be expressly conferred, but it has to be inferred from the provisions of a statute. It has to be gathered from the cumulative effect of the nature of the rights which are affected, the manner of the disposal which is provided, the objective criterion which is to be adopted, the phraseology which is used, the nature of the powers which is conferred, or the duty which is imposed on an authority, or other indica, which of course afforded by the statute. Maybe in short, I would say it like this, that a duty to act judicially, it may arise in widely different circumstances, and it is not possible, or it is never advisable to lay down a hard and fast rule, or what you call an inexorable rule of guidance. And applying this principle, he went on to hold that Section 53A of that Central Provinces and the Berar Municipalities Act of 1922, that could be exercised only on the happening of three conditions. Namely, one was the incompetence of the committee to perform its duties. Number two was the formation of the opinion by the state government that the appointment of a special officer would improve the working of the municipality. And thirdly, the obligation to pass a recent order. Now, he held that these three requirements call for a duty to act judicially, which includes a duty to give a hearing to the committee. Now, as we all know that this particular dissent ultimately found its fruition in A.K. Kraipak versus Union of India, 1969, 2 SCC 262, where it was held that the dividing line between administrative and quasi-judicial function has become quite indistinguishable, and that the test is whether the action of the authority that would affect the right or interest of a person, and if it does, he has to be heard, whether you can call it the principles of natural justice or you can call it as a duty to act fairly. Justice Subbarao's next dissent soon followed. It was in Basheshwarnath versus CIT Delhi and Rajasthan, AR 1959, Supreme Court 149, please 149. Now, the question which was raised therein was whether it was open to a citizen to waive the fundamental rights which are conferred upon him by Part 3 of our Constitution. Justice S.K. Das thought that this question really did not arise on the facts of that case, while Chief Justice S.R. Das and Justice J.L. Kapoor thought that whatever may be the position with respect to the other fundamental rights, a citizen can never waive the breach of Article 14. Because they were of the opinion that Article 14 was not a right which was conferred upon the citizen, but it was a mandate to the state not to discriminate. And since the said mandate is based upon public policy, the citizen has no right to waive it. Justice Subbarao, he goes on to take a more liberal view, and he held that the entire Part 3, not only 14, the entire Part 3, and not only merely Article 14, it were conceived in public interest, and that all of the rights which are conferred by Part 3, they confer rights upon the citizens. And he goes on to say that it is not proper that the fundamental rights which are created under various articles, they should be dissected to ascertain any or which part of them is conceived for the individual benefit. And accordingly, he held that no citizen can waive any of his fundamental rights. Justice Bhagwati in the judgment agreed to this view. And even today, Article 14 is known to have both a negative and an affirmative content. Now, the view which is propounded by Justice Subbarao. The next judgment of Justice Subbarao was Pandit M.S.M. Sharma versus Sri Krishna Sinha. It is AR 1959 Supreme Court, page 395, which we commonly, it is known as the Searchlight case, where we see another great dissent from this great judge. Now, the question was whether the press had the fundamental right under Article 19(1)(a) to publish the speech of the members of a legislature, which was expunged by the Speaker. And Justice Subbarao, in a very strong and progressive dissent, he demolished the claim of the majority, and he observed that the House of Lords asserted the privilege in 1801 when its proceedings were published malified, though they were expressly ordered to be expunged. He emphasized on the principles of democracy, and he went on to say that the proceedings of the houses of the parliament or the legislature that should be made public. It would be in the interest of the nation that the people of our country must know what is happening inside the house. And to support or rather fortify his reasoning, he refers to Chief Justice Cockburn in Watson versus Walter, 1868, Volume 4, Queen's Bench 73, who effectively, Chief Justice Cockburn, he rejected the significance of the privilege claimed in the modern democracy. And though amendments were made in Articles 105 and 194, Clause 3 of the Constitution, claiming transparency, the position remains basically the same as it stood earlier. And as all of us would know, Justice Venkatachalaya Commission had recommended that the privileges should be defined and codified for the free and independent functioning of the legislatures. Thus, the denial on the part of the legislature is against the spirit of the Constitution. And another great dissent of Justice Subbarao is Kharak Singh's case, Kharak Singh versus State of Uttar Pradesh, AIR 1963, Supreme Court 1295, which dealt with the validity of the UP police regulations, which raised a very, very interesting question to the meaning and scope of the expression personal liberty in Article 21. The majority took a very restricted view, but Justice Subbarao, he took a much more expansive view when Justice J.C. Shah agreed to Justice Subbarao. Justice Subbarao goes on to hold that no doubt the expression personal liberty, it's a comprehensive one. It's a comprehensive one. And the right to move is an attribute of personal liberty because it's a right to move freely. It's not merely a right to move, it's a right to move freely, as we see. Now, it is said that the freedom to move freely, that is carved out of the personal liberty, and therefore the expression personal liberty in Article 21, that excludes that attribute. Both are independent fundamental rights, though there is some overlapping to a certain extent. And there is no question of one being carved out of the another. The fundamental rights of life and personal liberty it has many attributes, and some of them are found in Article 19. Now, if a person's fundamental right under Article 21 is infringed, the state can rely upon a law to sustain the action. But that cannot be a complete answer unless that particular law satisfies the test which is laid down under Article 19 Clause 2. Because as far as the attributes of Article 19(1) are concerned, you can be limited only by way of Article 19 Clause 2. This we see in Maneka Gandhi. Justice Bhagavati held in the majority judgment. Justice Bhagavati goes on to say that the majority judgment in Rustam Kawasi Cooper, R.C. Cooper, the bank nationalization case of 70, that had the effect of overruling the majority opinion in Kharak Singh. Justice Bhagavati's decision in Maneka Gandhi, it would say that R.C. Cooper's decision of 1970, it has the effect of overruling the majority opinion in Kharak Singh and of approving. That means it is approving of the minority opinion or the minority judgment by Justice Subbarao. And we have another beautiful case, the right to privacy judgment, Justice K. A. Puttaswamy versus Union of India, AR 2017 Supreme Court 4161. Now, this is a judgment which is extremely relevant in the context of dissenting opinions. As I told you, in Kharak Singh, it was ruled. Hello?
Yeah, Prem, you're audible.
Yes, we can hear you. We can hear you. No problem.
Yeah.
You're both audible and visible.
Visible.
Am I visible?
Yeah, definitely, no issues.
Okay, so we were in, I think we were in Kharak Singh, right?
You had reached Puttaswamy.
Puttaswamy.
Of course, yeah, Puttaswamy. So we see the Puttaswamy judgment. That's a judgment which bears much relevance. Now that rules that the right to privacy, because as I told you, Kharak Singh ruled that the right to privacy was not a fundamental right. However, Justice Subbarao, who gave a dissenting opinion, taking the view that the right to privacy was indeed a fundamental right, and his view has been finally endorsed unanimously by the Supreme Court in this right to privacy case. And notably, in his opinion, Justice Rohinton Nariman, who again, in my opinion, is the greatest judge of the millennium, he terms this dissent as one of the three greatest dissents ever in the history of the Supreme Court. The other two, as Professor Dr. Kaul has pointed out, was the ADM Jabalpur case of Justice H.R. Khanna, and the other one, A.K. Gopalan's case by Justice Fazal Ali. Now, finally, Justice Subbarao's dissenting view in the New Money Chowk Spinning and Weaving Company Limited, Ahmedabad, versus the Textile Labor Association. That's reported in AR 1961, Supreme Court 867. That laid down the very foundation of the Payment of Bonus Act of 1965. Next in the line, I would say it is Justice Mudholkar. Because Justice Mudholkar was the first judge who theorized the basic features of the Constitution in one of his greatest dissent in Sajjan Singh versus State of Rajasthan, AER 1965 Supreme Court 845. Before that, we had the Shankari Prasad case. Now, Sajjan Singh deals with the Constitution's 17th Amendment Act to the Constitution, which was during 1964. That was under challenge. Articles 31A and 31B, it was challenged to a repetition. And the doctrine of pith and substance test, that was applied by the Supreme Court in the case. Amongst the 5 judges who were on the bench, 2 judges dissented. One was Justice Mudholkar and the other was Justice Hidayatullah. That judgment, Justice Mudholkar, he went on to say that the basic features or the fundamental features of the Constitution cannot be changed and no alterations can be made in the basic features or fundamental features of the Indian Constitution. See, the wise judge, Keshavananda Bharati, of course, it's a 13-judge bench. 1973 4 SCC 225, in which we learned the basic structure doctrine. But mind you, the genesis of this basic structure doctrine is the dissent of Justice Mudholkar in Sajjan Singh. And Justice Mudholkar, as one could, if you could read the judgment in Sajjan Singh, he drew upon a Pakistan Supreme Court's decision. It's a very good decision. Fazlul Qadir Chowdhury versus Muhammad Abdul Haq. That's a 63 decision of the Supreme Court of Pakistan, which had based the basic structure doctrine already. It had used them. And the phrase basic structure or the basic feature of the Indian Constitution. Of course, you can see it even before Justice Mudholkar pointed it out in 1964. For instance, I would tell you, one is the judgment in that Indre Barubari Union, an 8-judge bench, AR 1960 Supreme Court 845, which of course dealt with a reference by the President of India on the implementation of an Indo-Pak agreement relating to the Barubari Union and the exchange of enclaves, which included the Coast Bihar and everything. Enclaves as a. Then the next one you have in State of West Bengal versus Union of India, AR 1963 Supreme Court 1241, which was a 6-judge, which in fact considered a suit by the State of West Bengal against the Union of India, seeking to declare that the Parliament was not competent to make any law authorizing the Union government for acquisition of land and rights in or over any land which are vested in the state, and said that there was something what we call the Coal Bearing Areas Acquisition and Development Act of 1957. These two rulings, you can see the words basic feature or basic, the phrases basic structure and basic feature. But it has been used in a very, very looser sense and not squarely in the context of the implied limitations to the amending powers which we see in Article 368. So it is then, of course, fair to say that it is Justice Mudholkar who made the first important introduction of this concept into our constitutional jurisprudence. The next judge whom I am reminded of is Justice Hidayatullah, who is, of course, known for his great dissents. The first dissent comes in New India Sugar Mills versus Commission of Sales Tax Bihar, AIR 1963 Supreme Court 1207, that dealt with a case under the Sugar and Sugar Products Control Order of 1946, and also with respect to the aspect of sale, which could be taxed under the Bihar Sales Tax Act of 1947. The majority refers to the Sale of Goods Act of 1930 and holds there was no sale and hence there is no question of taxation. Justice Hidayatullah, he took note of the sales tax imposed on the goods assumed by different firms in different countries, which led to the recommendations of the Taxation Inquiry Committee for the entry in the Government of India Act of 1935. And he interpreted the word sale referring to the Roman law of MTO Vindicio, as well as the Contract Act of 1872. And he held that in the transactions there was a sale of sugar for a price and the tax was payable. This dissent was later upheld by a 7-judge bench of the Apex Court in Vishnu Agencies versus Commercial Tax Officer. That was 1978, Volume 1 SCC 520. The next dissenting judgment of Justice Hidayatullah was in Bhagwan Das Kedia versus Giridhar Lal Purushottam Das, AIR 1966 Supreme Court, page 543, where the plaintiff in that particular case were the respondents in the appeal. They entered into a contract with the appellants by virtue of a long distance telephone call, and the proposal was spoken by the respondent at Ahmedabad, and the acceptance was spoken by the appellants at a place called Khangaon. Now, the question of jurisdiction. The trial court finds that the plaintiff makes the offer from Ahmedabad by over telephone to the defendants to purchase the goods, and the defendants offered that particular thing at Khangaon, that the goods were under the contract to be delivered at Khangaon and that the payment also should be made at Khangaon. So the contract in view of the court was to be performed at Khamgaon. And because the offer was made from Ahmedabad to purchase the goods, then the court at Ahmedabad could not be invested with the jurisdiction to entertain the suit. But the court held that when a contract is made by a conversation on telephone, the place where acceptance of offer is initiated, or rather it is intimated to the offerer, it is the place of where the contract is made, and then only the civil court at Ahmedabad had the jurisdiction to try it. A revision was taken up by the defendants against the order which directed that the suit be proceeded on merits. It was rejected in limine by the High Court of Gujarat, against which appeal goes to the Supreme Court of India. And the majority preferred to endorse the rule which was laid down in the famous Telex case, Entos Limited versus Miles Far East. That's a 55 Queen's Bench decision, 55-2 Queen's Bench 327. That where a contract was made by an instantaneous communication, like telephone, the contract is complete only when the acceptance is received by the offerer, since an acceptance must be notified to the offerer to make a binding contract. And the court upheld the judgment of the trial court, which took view that a part of cause of action arose within the jurisdiction of the city civil court at Ahmedabad, where the acceptance was communicated by telephone to the plaintiffs. Justice Hidayatullah, he dissented. He painstakingly deduced that there are four classes of cases which could occur when contracts are made by telephone. Number one, where the acceptance is fully heard and understood. Number two, where the telephone fails as a machine and the proposer does not hear the acceptor, and the acceptor knows that his acceptance has not been transmitted fully. Number three, where owing to some fault at the proposer's end, the acceptance is not heard by him and he does not ask the acceptor to repeat his acceptance, and the acceptor believes that the acceptance has been communicated. And finally, where the acceptance has not been heard by the proposer and he informs the acceptor about this and asks him to repeat the words. Now, these four classes of cases were enumerated, considering the very nature of the language which is employed in Section 4 of the Indian Contract Act. Justice Hidayatullah held that it covers the case of communication over telephone, that the contract was complete at Khamgaon and allowed the appeal with cost. But the lone dissenting voice, of course, in my opinion, that is the best judgment. That is the best judgment. Maybe in a couple of years, maybe, because this would become good law, because this is a good law. And the majority judgment, it does not, it's not conducive to much clarity, because Section 4 itself, if you read Section 4 of the contract and the plain language would suggest otherwise. Now, another great dissent which I have had an occasion to go through was the case of Naresh Sridhar Mirajkar versus State of Maharashtra, the 9-judge bench, AR 1967, Supreme Court, page 1. Now, this was a case where Justice Tara Kunde's oral order from the Bombay High Court, which was one forbidding the publication of what transpired in the court during the recording of evidence in a defamation case. And Justice Tara Kunde at that point of time, he added in the open court that no written order was necessary and he expected that his oral order by itself would be obeyed. Now, that was violative of Article 19(1)(a) of the Constitution. And as against a majority of 8 learned judges, Justice Hidayatullah held that judges, both in the administrative as well as in the judicial capacity, they are not totally immune from challenge of infringement of fundamental guarantees. He said that it is true that judges are the upholders of the Constitution and the laws, are least likely to err, but the possibility of their acting contrary to the Constitution, that can never be completely excluded. And by way of a very beautiful illustration in the judgment, he would go on to say that a judge, without any reason, orders the members of, say, one political party out of his court. those so ordered, they can seek to enforce their fundamental rights against the judge. And it should make no difference that the order is made while the particular person sits as a judge. Even if an appeal lies against the order, the defect on which the relief could be claimed is a very breach of fundamental rights. And Justice Hidayatullah holds that the judges could not prohibit the publication of what transpired in the open court because such proceedings were open to all Indian citizens as public hearing of cases before the courts. That is the very fundamental to our democracy and the system of justice of any other country. And considering, now this is a very important point, considering whether a repetition under Article 32 can lie against a judge in respect of any action which was performed by him while he adorned the seat of justice, interpreting the definition of state within the meaning of Article 12, he held that the definition does not say fully what may be included in the word state. But although it says that the word includes certain authorities, it does not consider it necessary to say that the court and judges are excluded. He goes on to consider Article 20, which speaks of convictions for offences, punishments and testimonial compulsion, which is addressed as much to the courts as to the executive and the other authorities, venturing to think that the worst offenders would be the courts if they went against this particular prescription. And he quashed, as against other 8 judges, he quashed the order of Justice Tarakunde and declared that the forbidden testimony is capable of being reported in extenso in any newspaper in India. And this outstanding dissent, it is fortified by remarkable reasoning, which if you can read, fortified by remarkable reasoning. Next in the line is, I would say, it is Chief Justice B.P. Sinha. Chief Justices have dissented only a very few times. Chief Justice Sinha was the second to dissent. His dissent in Sardar Tahir Saifuddin case, Sardar Tahir Saifuddin versus State of Bombay, that was AR 1962 Supreme Court 853, which we popularly call the Dawoodi Bohra case. That's a very passionate defense of the individual's right not to be arbitrarily excommunicated from his community. And that is still a masterpiece which draws together the constitutional prohibition of untouchability and ideas of cultural pluralism. That's one of the greatest dissent. Really good dissent. And next in the line, because as Dr. Kaul put it, we have dissents, it has to be segregated, as Dr. Kaul said, into 2, up to this ADM Jabalpur, I mean the Maneka Gandhi judgment, and from there. I will classify it as 3. Now next in the line, it would be the ADM Jabalpur case, which was one of the greatest dissent in the history of the courts all throughout the world, which was dissent by Justice H.R. Khanna in the ADM Jabalpur case. ADM Jabalpur versus Shivkant Shukla, AR 1976 Supreme Court 1207, which popularly we know as the habeas corpus case, and which was decided by the Supreme Court during 1976 by a 5-judge bench. It was the Additional District Magistrate of Jabalpur. He appeals against the Madhya Pradesh High Court's verdict favoring the detainee Shivkant Shukla, which was a lead case. It was a batch of cases actually. This was a lead case. Because Supreme Court set aside 9 High Court judgments, including the one in Madhya Pradesh High Court, which had ruled in favor of the enforcement of the fundamental rights during the emergency, upholding the presidential order dated 27th June 1975. And the majority concluded that the presidential order declared that the right of any person, even to move any court for the enforcement of the rights which are conferred under Article 14, 21 and 22 of the Constitution, and all proceedings which are pending in any court for the enforcement of all those valuable rights, that would stand suspended for the period during which the proclamation of emergency was enforced. Now see, what a great judge. Justice H.R. Khanna, he rejected the majority view in the most righteous indignation, and he goes on to hold that Article 21 cannot be considered to be the sole repository of what we call the right of life and personal liberty. The sanctity of life and liberty, that was not something which was new when the Constitution was drafted. And the principle that no one shall be deprived of his life and liberty without the authority of law, that was not the gift of the Constitution. And that even in the absence of Article 21, the state has absolutely no powers to deprive a person of his life or liberty, except with the authority of law. And he goes on to reason that even before the Constitution came into force, prior to the Constitution, no one could be deprived of such a liberty. And such a law continued to be in force after the Constitution comes into force in view of Article 372. And this lone dissent came up, after 4 decades, that ripens to law in Justice Puttaswamy. Justice Puttaswamy versus Union of India, AR 2017, Supreme Court 4161. I have already said about this judgment. And one can never forget that this dissent, as spoken by Dr. Kaul, caused Justice H.R. Khanna the very post of Chief Justice of India, while overlooking his seniority. Justice Baig was appointed as the Chief Justice of India, as a result of which Justice Khanna was forced to resign. And a lot has been said and a lot has been written about the circumstances that has shaped the majority opinion and the backlash which was faced by Justice Khanna, going to the side he was to choose. And suffice to say that Justice Khanna's dissenting opinion that was instrumental in the rise of the voice of the dissent in the future judgments of the Supreme Court. And the life of the flawed majority in the ADM Jabalpur case, it was predictably, it was numbered. It was symbolic. Then why it was symbolic? Because it was the son, Justice Dhananjay Chandrachud, who authored the eulogy in Justice Puttaswamy case, that's the right to privacy case, bringing the father Justice Chandrachud's judgment to an end. Next in the line after this 70s, in the 80s, we have the dissent of Justice Bhagwati in Bachchan Singh versus State of Punjab, which every one of us knows, because which was one regarding the constitutional validity for providing death sentence as an alternative punishment for murder under 302 of the IPC. Justice Bhagwati dissented. That was another good dissent. Then we have Justice A.R. Lakshmana's case, because from 80 onwards to 2000, you don't see much dissents. It declined, totally declined. Then you have one of the good dissents by Justice A.R. Lakshmana in the Acharya Avadhuda's case. That is Commission of Police versus Acharya Avadhuda, 2004-12 SCC 770. But it was a 3-judge bench. But it was dissented by Justice Lakshmana, who allows the Anandamargi sect to perform the Tandav dance. That is, it is one of the best defense in our constitutional history of the right of the individuals and the communities to determine for themselves what their religion means to them and demands of them. That too, it's a historical one in my eyes. Then you have Justice S.B. Sinha's dissent in Z Telefilms Limited versus Union of India, AR 2005 Supreme Court 2677, wherein the principal question was whether the Board of Control for Cricket in India, BCCI, that was a state within the meaning of Article 12. And the majority held that no, BCCI cannot be held to be a state for the purpose of Article 12. Wherein Justice Sinha was a lone dissenter. He goes on to say, yes, of course it is. He would say that he holds that BCCI falls within the term other authorities. And later we see in BCCI versus Cricket Association, I think of Bihar, 2015, 3 SCC 251. It was a division bench of the Supreme Court. It has held that even though BCCI is not a state within the meaning of Article 12 of our Constitution, since it discharges some important public functions, it is amenable to the jurisdiction under Article 226. Justice Ramkumar would be knowing this ruling much better, because he was the ombudsman for the Cricket Control Board. So He may be knowing this particular judgment in detail more than me. Another great judgment, in my opinion, of this day, I mean, recently was by Justice Chalameshwar in Supreme Court Advocates on
Yes.
Record Association versus Union of India. That is 2016 5 SCC page 1, which we know as the NJAC case, which dissent, I would say it would draw parallel between him and Justice H.R. Khanna. Because that lone dissent, it's a beautiful dissent. And just read the judgment. Wisely put. Such a judgment has never come. That draws parallels between him and Justice H.R. Khanna. I have no hesitation to say like that. Now, he was a lone judge in the bench to uphold the validity of the National Judicial Appointments Commission Act of 2014, which was the very subject matter of challenge. And he held that transparency, it is a vital factor in constitutional governance, which also was a very facet of rationality. The need for being transparent is more in the cases of appointment process and proceedings of the collegium. It were something like what you call absolutely opaque and inaccessible both to the public and as well as we have that history also, barring occasional leaks were there, as we all know. Now, he went on to boldly hold that the assumption that the primacy of judiciary, the appointment of judges, that's a very basic feature of the Constitution. That is, empirically it is flawed. This is the word which is used, pointing out that there were cases where the Apex Court Collegium had to retrace its steps after rejecting the recommendations of a particular name suggested by the High Court Collegiums, giving scope for a great deal of speculation. Why I would say this is, just see, now the collegium system is like the High Court recommending names and the Supreme Court just, of course, later on passes it. And we have had occasions where the names which were sent by the High Courts were rejected. It was never considered by the collegium. What does that mean? One is the eligibility and the suitability, only the High Court knows. The Supreme Court doesn't know it. It has no idea about the candidate. But why the Supreme Court rejects when the High Court really said that here, look here, we have, this is the set of the eligible and suitable candidates we have. And kindly see when the Supreme Court rejects it. Doesn't it cast something against a High Court which has sent those names? Definitely yes. So said Justice Chalameshwar. So he said. And he held that the present collegium system that lacks transparency, accountability and objectivity, which view that was to a certain extent that was agreed to by Justice Kurian Joseph. Also, he also in his judgment would go on to say like that. Actually, even though he did not dissent, he of course expressed in agreement with Justice Chalameshwar. He went on to say like this. And Justice Chalameshwar, he said that the exclusion of the government from the process of appointing the judges, that would be totally illogical and inconsistent with the very foundations of the theory of democracy. And it's a doctrinal heresy, adding that the Attorney General, at that point of time, Mughal Rohatgi, he was right in his submission that the exclusion of the executive branch is destructive of the very basic feature of checks and balances, a fundamental principle in the constitutional theory. Just see how what a brilliant judgment! What a brilliant judgment! Another great judgment soon follows is Justice Dhananjay Chandrachud's dissenting opinion in Justice Puttaswamy case of 2019, which we know as it's not the right to privacy judgment, it's known as Aadhaar judgment. 2019, 1 SCC page 1. It was the Aadhaar case. It was talking point of say several debates, political and judicial, and the Supreme Court of Jamaica, as we all know, in a case which is called as Julian Robinson versus Attorney General of Jamaica. That's again a 2019 Jamaican decision that has placed reliance upon Justice Chandrachud's dissenting opinion over the majority opinion in the Aadhaar case to strike down the provisions of the National Identification and Registration Act enacted by the Parliament of Jamaica, requiring the citizens to provide the biometric and the data which they declared as unconstitutional. And as a debate regarding the right to privacy was pitted against the Aadhaar scheme, this is definitely not the last we hear about Justice Chandrachud's dissenting opinion in the Aadhaar case. I would say that I term that Justice Nariman is the greatest judge of the millennium, and I would term Justice Dhananjay Chandrachud is the second greatest judge of this millennium, in my opinion, in my humble. Then you have another great dissent by the lady judge, Justice Indu Malhotra's dissent in the Sabarimala case, Indian Young Lawyers Association versus State of Kerala, 2019 11 SCC page 1, which we know as the Sabarimala case. Equally noteworthy, it contains actually that particular dissent, it contains thought-provoking discussion on the issue whether the courts ought to dwell into the realm of the facets that constitute essential religious practice and whether interfering with the religious practices will militate with the rights guaranteed under Article 25(1). Now, as we all know, a 9-judge constitutional bench of the Supreme Court upheld the decision of the Sabarimala review bench to refer this particular questions to a larger bench on the ambit and scope of the religious freedom practiced by multiple faiths all across the length and breadth of the country. And now it has framed 7 questions which are now to be considered by this 9-judge bench. Justice Indu Malhotra's dissenting opinion, that definitely it would provide food for thought and it will set the tone for further debate and deliberation in this 9-judge bench, which we are all waiting to come. Now, having dealt with some of the greatest dissents of India, because we have termed, this particular topic we have termed as the effulgent daffodils in the history. So I need to make mention of the fact, not only in India, the United States Supreme Court, you have it's replete with glowing examples of dissenting opinions in the cases of constitutional law in the history of the United States as well. Now, you can see the United States Supreme Court in one of the cases was Justice Benjamin Curtis. A groundbreaking dissent comes in the famous case Dred Scott versus Sanford, 1856 decision, where the majority view, that was, as US Supreme Court always sits in number of all the 9 judges would sit, and there the majority view was by 7 judges, that the descendants of the slaves from Africa, they did not have the right to citizenship. And the other dissenting judge was Justice McLean. Subsequently, the 13th, 14th, and 15th amendments of the US Constitution that overturned the majority view. Another historic dissent, Justice John Marshall Harlan, in the case of Plessy versus Ferguson, an 1896 case, which involved the issue of racial segregation in the facilities, that was marked by his emphatic words that the Constitution is colorblind. The core issue, that was whether there should be separate compartments for white persons and persons of colored races in trains. The use of a compartment which was meant for another race would entail imposition of fine or punishment. The majority upheld this policy of segregation. The futurist views of Justice Harlan on the civil rights that got affirmed in the case of Brown versus Board of Education during 1954 by a thumping majority, all the 9 judges, all the 9 by a thumping majority, all the 9 judges of the United States Supreme Court agreeing with the earlier dissent. Then another notable dissent comes from Justice Louis Brandeis, who of course was a person who was who championed against dissents. He gave a very few dissents. Now his view was, don't dissent. First let us set all the laws right, and then we would have the dissenting opinion. Which was diametrically opposite to what the proposition which was laid down by Charles Evanchoose, as I said, who termed the dissent. Now, Justice Brandeis dissent in the Olmsted versus United States, that's a 1928 case, which was one regarding the permissibility of wiretapping, which of course was subsequently declared as unconstitutional seizure under the Fourth Amendment in Katz versus United States, a 1967 decision. Then we have Justice Porter Stewart in the case of Abington School versus Shem, that's a 1963 judgment, which involved compulsory reading of the Bible in the school every day before the class, which was termed to be against the realization of what is called the state neutrality by Justice Stewart, and discussion on dissenting opinions in the context of US Supreme Court cannot be complete without mentioning the great Justice Antonin Scalia. He is considered to be the author of one of the most significant dissenting opinions in the recent history of the US Supreme Court. Morrison versus Olson, a 1988 decision which involved the challenge to the jurisdictional powers of the Office of the Independent Counsel, where Justice Scalia weighed in with a lone dissent, branding the Office of the Independent Counsel as an institution that will do great harm to the country. So that it is incalculable harm it's caused. Subsequently, the Congress let the Independence Act expire in 1999, and his dissent again comes during the year 2003 in Lawrence versus Texas, which eventually made a persuasive case in favor of the legalization of the gay marriages, which we have now also. The gay marriages they had in, I think it was Obergefell versus Holtz. Obergefell versus Holtz. It's a 2015 decision. This 2015
Good evening.
Then likewise in the United Kingdom, one of the most well-known dissenting opinion comes in the case of Liversidge versus Anderson, 1941 UK House of Lords, page 1, which involves a question of curtailment of civil liberty by the executive on the ground of reasonable cause. And it was none other than Lord Atkins who renders the dissenting opinion. And he gave an interpretation which favored the exercise of the power of judicial review over such executive action. And later on, Lord Atkins' interpretation was preferred over the majority view in the Supreme Court judgment in HM Treasury versus Ahmed, 2010, UK Supreme Court, page 2. And as we could notice that the number of dissenting opinions were the highest in the initial decades that followed the establishment of the Supreme Court. The judges of 50s and 60s dissented vigorously. In the first decade, that is 50 to 60, you can see around 91 dissents came out of around 2,144 cases. Then, that is in the next decade, this particular trend peaked to 235. First you had 91, peaks up to 235. It was almost say like 4,000 cases. And during 70s to 90s, you can say up to 2000 itself, the number of dissents which disapprove the executive action or the curtailment of constitutional rights substantially decreased. Dissenting opinions constituted only say less than 1% of the total number of decided cases. And yet some of the dissenting views paved the way for development of the future law. And such opinions, they have, I would say singularly, they have provoked the legislature even to change or enact the laws. Now the only plausible explanation is that by all accounts, the judiciary, it was not free from the influence of the executive during that particular period. Maybe not surprisingly, I could say that this particular period saw the most talked about dissent. That when you did not see much dissents, the most talked about dissent of Justice H.R. Khanna in the form of H.R. Khanna in ADM Jabalpur, where he came out strongly in favor of the individual's life and liberty and the predominance of the fundamental rights as against what I could say that the strong arm tactics of the executive. And a sea change took place in the Supreme Court's approach with the independence being firmly established as a bedrock of judiciary. Now this gradually, I would say that led to the re-emergence of the dissenting opinions. Numbers were relatively low. Now, just say between 1990 up to 2016, where we had around, hardly few, maybe less than 40 judgments were there. Less than 40 judgments, dissenting opinions were rendered. 1990 to 2016, you can see they carried the dissenting opinions. And the following 4 years, that is 2016 to 2020, we saw some great dissenting opinions, like Justice Jersey Chelameshwar's dissent in the NJC case, Justice G.Y. Chandrachud in the Aadhaar judgment, Justice Indu Malhotra in the Sabarimala case. Now, this all would reflect the pattern that the number of dissenting opinions which is rendered by the Supreme Court in the constitutional case law, it is too low. Now, statistics seemingly that manifests a disinclination of the Supreme Court to dissent, despite you say that India is the largest democracy in this whole world. And while the three great dissents, as termed by His Lordship Justice Nariman, Justice Fazl Ali Neke Gopalan, Justice Subbarao in Kharak Singh, and Justice H.R. Khanna in ADM Jabalpur, they continue to stand tall. The other three dissenting opinions, one of Justice Chelameshwar in the NJC judgment, of Justice Chandrachud in the Aadhaar judgment, and Justice Indu Malhotra in the Sabarimala case, those three should deserve to be reckoned as the three greatest dissents of our times. Now, before ending my talk, I would tell you another great dissent, which was a pre-independence era dissent, which bears high significance. Justice Mahmood, in his dissenting judgment in the full bench case in Narsingh Das versus Mangal Dubey, 1883 ILR, Volume 5 ILR, Allahabad 163. He goes on to observe that the courts are not to act upon the principle that every procedure is prohibited unless it is expressly provided for by the court, but on the converse principle that every procedure is to be understood as permissible till it is shown to be prohibited by law. And as a matter of general principle, prohibitions cannot be pursued. And in the present case, which was the case before him, he went on to say that it should rest upon those defendants to show that in which form the suit was barred or the suit was prohibited. And he said, no, one cannot easily pursue that this is prohibited. Now, this is a particular dissent in the pre-independence era, which developed into and which later on crystallized into law, which was accepted by our Supreme Court in a plethora of precedents. For instance, I would cite the New India Assurance Company versus Srinivasan, that is 2000 Volume 3 SCC 342. Then the same was approved in Indian Oil Corporation versus Lakshmi Shankar Narayan. That's a 1999 SCC 27. So it is said that in the Jewish cultural history, there is a tradition of prophets who appear in times of desperate need and warn their people that they are walking on a wrong path. One that will only end in ruin and devastation. Our constitutional history has had its own share of prophets. I mean, prophets who have, in the form of these great judges, who have expressed themselves so eloquently and powerfully through their dissenting opinions. And the dissenting tradition is perhaps the most important tradition that we have, indispensable for keeping our constitution alive, and a thing of what I would say the flesh, blood, and dreams. And these dissents, they strengthen the value of our free speech and expression, and they are based on effective and judicious considerations. In the recent past, of course, we saw a gradual decline in the free expression of dissent, and this declining trend of dissenting opinions, it is capable of raising several questions, including the credibility of the Indian judicial system among the public. And it is the inherent power of dissent that helps us to build the very foundation of democracy. And it is, as I said, that this particular power of dissent, it keeps our nation afloat. And we tend to equate agreement with unity. We often bemoan a lack of common ideals when a government is elected by a slight margin rather than by a landslide margin, or were say a committee motion passes with a single swing vote across a sharply divided issue. We think if only we were more ideologically cohesive, more strongly allied together, more resonant with common goals, imagine what we might accomplish if we were all of one mind. Just imagine, you would shudder. And when you hear some ridiculous prattlings or which echoes across the floors of an ideological divide, just remember the linchpin upon which your freedom is founded. It is important that we all agree. It is only important that we are able to disagree. And that brings me to the end of my talk. And thank you all for a very patient listening. Thank you so much.
Wonderful, Prem. Wonderful. I'd say it reminds us of an advertisement for a soft drink earlier on, wherein the tagline was just imagine if everybody looked alike, think alike, and even drink alike. So, saying that from the cola age, let us move on to something entirely different. Now, the person who introduced the subject, Kaul, your comments, and we'll move on to Ramkumar.
I think he has covered a vast area, and he has ultimately said that we must agree to disagree. It's not always good to agree. Thank you. Thank you very much.
Sir, over to you, Ramkumar, sir.
Wow. The ready reckoner in Premraj Menon has been at his best today. See the felicity with which he marshaled the law and facts, impromptu, extempore of the dissenting judges, not only in India, USA, UK, is simply marvelous, gorgeous, and awesome, if not fabulous. The great judges of India and abroad who sowed the seeds of change, whether you call them lone dissenters or lone crusaders, were endowed with infinite wisdom and clairvoyance, I would say clairvoyance, to foresee the law in its true spirit is definitely a providential gift, if not wisdom. It is not merely a discordant note by way of dissent, flowing against the current. It involves intelligent application of mind. It involves, and it has contributed to the development of law, not only in India, elsewhere. Great judges and great talk, wonderful talk, excellent talk, Mr. Premraj.
Thank you. Justice Roshan Dalvi.
I was amazed. These youngsters say it is amazing, but I thought this was also amazing.
Amazing.
And I am reminded of two great people. One is Dr. N.R. Madhav Menon. And I think Premraj has such a long way to go, he might reach the oracles of Dr. Menon, with whom I have worked and whom I hold in the highest esteem as a jurist in India. The other was Leo Tolstoy. He had spoken in literature about dissent because there are so many opinions for any subject. And he said that we may not agree with somebody's opinion, but we must respect that opinion. So he says, I do not agree with you, but I will defend to my death your right of saying so. And that is what is our dissent. So thanks, Premraj, for so many such dissents that you gave us.
Thank you so much.
Joshi.
I'm literally speechless. She's amazed. I'm speechless. Nothing else to add, but it was a wonderful exposition of all the dissenting judgments. And we are really, astonished how many dissents and so many wonderful judgments which we have got from this dissent, and one day they are bound to be the majority judgments, as you have rightly said, and they have really contributed to the development of law. What is important from the democratic point of view is to respect the dissent, and your exposition has made us think over it. made us really introspect over it. And I was also wondering when initially I was listening to you, why there are so less number of dissent. But then some of the answers you have given, and those are really the valid answers. Some answers may be because of the composition of the benches. You know, the Chief Justice,
Correct.
when he is composing the bench, I mean, there may not be leaving any scope for the dissent. That may be another reason. There may be several other reasons. There may be some judgments like Romila Thapar, wherein Justice Chandrachud has, I mean, recent judgment wherein Chandrachud has really dissented, and it pertains to, again, the liberty of the activists. So many, I mean, you know, some judges only dissent and why others don't. That is also one more question, maybe because they don't get the opportunity. So there are several issues, but it was really an excellent exposition of law. You have covered the topic from every aspect, and we are blessed. Thank you.
Thank you so much.
Justice
And
Rameshan.
you must get it documented.
Yeah.
Please get this documented, you know, in a kind of a statement form. And
All
another
right.
one thing,
You can
remember your
circulate
mother
it
is
as a
hearing.
bulletin or speech.
All extempore from his memory.
Oh, really? With page number? Everything.
He's a young man, so he has to remember them. No, Justice Chagla was always say that by sitting in the library, you don't have to make the notes. You must remember them up here. So when you remember in your mind, they will never forget them.
Exactly.
So young people must, at least, if we old people cannot.
Yes. Rameshan, sir.
As usual, I'm a latecomer today. Because I heard my own reasons for that, because I'm conducting sitting in the video conference, and as then more expected, time is consuming by hearing cases are there. So I could not attend from the beginning. But however, really, as Ramkumar, Professor Gaul, Dalvi Madam, and Shalini has said, the memory power of Premraj has to be appreciated. One.
So the next session is the secret of the memory power of Prem.
That is he is going to tell. The same
That
thing.
he will
He will
not
have to
divulge.
give. He will have to give.
He will not divulge.
It is sometimes it is a trade secret.
Yes.
Really, one thing is there, because it is always better in a democracy. You must have a dissenting voice. Unless you have got a strong dissenting voice, democracy will not survive. So that way, a dissenting judgments sometimes will be an eye opener for a new thinking in the coming future. That is how H.R. Khanna's decision, Chandrachud's decision, etc. were later taken as the milestone for laying down fresh decisions also on the same aspect. Probably, I think that even in the Sabarimala case, sometimes the Padmanabh Swami's present case may also be influenced. Because of the database, it has been thought that the right of religious freedom is something which expected to be kept away from the court sometimes. That is what the trend goes sometimes. So we do not know what will happen to the reference case, because Article 25 and 26, how far it can be interpreted, how this can be used, how it can be conflict with Section 14, all these things are going to be decided in that case. Really wonderful speech, that too extempore, remembering all the judges' name, not only in Indian judges but also foreign judges, because we don't get an opportunity to see the foreign judgments sometimes, but you are getting time to go through all those aspects, and also using those things at an appropriate time, in the appropriate place, in a right way also. Thank you very much, Mr. Premraj, for your valuable contribution on this. Thank you very much.
Thank you, sir. Thank you so much.
That was wonderful, Prem. And the question you put a couple of sessions ago, I think it was to Bhati ma'am, wherein you had asked whether it is the majority judgment or minority judgment when it comes to prospective overruling. In democracy, majority minority is good for ruling, or rather to form a government. But when certainty is the bedrock of the very basis of the faith of the citizenry on the judicial system is this sort of indulgence, apart from the glamour and everything associated with it, good for the system?
See, number one, if you say about minority and majority, Article 145, Clause 5 of the Indian Constitution, that provides for the majority opinion of the judges. It is to be taken into consideration. However, the judges are free to write their own dissenting opinions. If they feel that the majority opinion is either inconsistent or it may require an alternative approach other than what has been adopted by the majority. And this accords in really, I would call it as a mental independence upon the judges to think and to opine in a manner which they think is completely rational. However, as much as this provision seems highly perfect in theory, practically speaking, it portrays a far cry from reality and practicality. The importance of recognizing the dissenting opinions, the dissenters, it is per se linked to the judicial autonomy and the complete exercise of democracy in its truest essence. What you call the factum probans, which concerns the dissenting judgments. It is the necessity to wield the judges with the power and independence to decide in a completely non-partisan manner, such that it inculcates a sense of what you literally call the progressive thinking. Now see, the evolution of law and society is possible only with the recognition of dissent by lending your ears to the dissenters. Or isn't it entirely wrong to think that the dissent and the democracy, they are two sides of the same coin? So long as dissent takes a backstage in a democracy, such a kind of democracy remains only a democracy in theory. A democratic rule, it fails in practice, not in theory, in practice, when the dissenters aren't given a voice, eventually leading to the acceptance of a totalitarian opinion and eventually giving rise to what you could call as a mobocracy. Dissenting opinions, they aid in the evolution of law. Particularly it would do away with those that are redundant and amending those that would require to see the light of change. And by suppressing the dissenters, not only is the dissenter victimized, it also proves highly detrimental to the very practice of democracy. The dissent in a democracy should be viewed in a very healthy fashion and must not be suppressed. The need to politicize it or maybe by all means, it should be discouraged. And to conclude, you can take note of one thing, that the dissenting opinions, they form the very backbone of any democracy. Merely suppressing a dissenter would mean to wreak havoc in the society. The sanctity and independence which are wielded to each and every judgment, that must and should be respected, because after all, every judge in the Supreme Court is a human being. And among such an intellectual conglomeration of learned stalwarts, dissent, disagreement, debates, everything is bound to arise. Therefore, such conflict of interest and debates must be highly encouraged, and each individual's personal opinion that should be respected. And suppressing them only would aggravate the problem by adding fuel to fire. And it is extremely important that the dissenters are heard out so as to perceive what they would say. And lastly, I am reminded of Albert Einstein's quote: blind belief in authority is the greatest enemy of truth. Similarly, blind acceptance of a majority shall not always yield to truth, and the floor must be open for debate and deliberation to arrive at the penultimate truth. And as you put it, when I think I made it clear to Ms. Aishwarya Bhatti and Justice Pushpendra Bhatti, that was regarding, it was not in this sense. That was a case where they were on the principle of what they call the doctrine of prospective overruling. Golaknath, following Golaknath, we have seen the Supreme Court in prospective overruling in a many number of cases. Even as Professor Kaur would know, that even in that independent thought judgment, even though it's not a prospective overruling, Supreme Court goes on to say in 2017 that, look here, IPC section 376 is an explanation. Read the words as 18 instead of 16. from this date onwards. See, actually, what is the doctrine of prospective overruling? Just see the Goraknath judgment. 11 judges, 6-5, of course, the fractured majority regarding amendment. But regarding the doctrine of prospective overruling, there is no majority at all. Only 3 judges were there, and 8 is another way. At least 5, 6 is another way. 2, they did not say anything. Just see the separate judgment, Justice Vanchu's judgment. It had no majority. So, doctrine of prospective overruling, I think the doctrine must fail because they don't have the majority in the judgment. Because I had a close reading of Goraknath. It does not give rise to a prospective, because in that particular case, of course, it was highly requisite, or else it would have proved very, very fatal. Because instead of prospective overruling, if they did something, because just see the 9th schedule, everything has to go. It will tumble down. Maybe it would have take a heavy toll on our very constitution.
Prem, the issue that was lingering in many minds was something different, in the sense like if you have a legislation which is loosely worded, or if you feel that the legislation isn't good enough, you say the legislature has not done the job properly, that is why others have to step in. When the executive does something, we say executive excesses. But judgment, the court, what is a common man expecting from a court? A quietus of the issue, a final adjudication of the issues, not a show of the what do you call the academic pursuits or ankles that could be had on a. Finally, they require a settlement of the dispute. If there is no mechanism by which that could be had, but have different opinions and things like that, the question that was raised was, does it not send a wrong message to the community, to society at large, that the decision makers are not at unison with what is to be decided, and there again there is some sort of mechanism by which a decision is being rendered when there is a scope for something. On a lighter vein, a witness who was acting silly in the court was asked, do you know the consequence of that? He said, yes, I told everybody at home and came. What did you say? I said that 3 places if you go, nothing is certain. 3 places, what is it? 1 is fishing in the high seas, number 2 is going for a war, and 3rd is going to a court of law. That's only on that background that question was put. We have Justice Nagamuthu here. Nagamuthu sir, can you unmute and come forward? Please sir, Nagamuthu sir. You'll have to unmute. Justice Vasant just sent a message because there is some function going on in the Supreme Court. He had to attend something like that. Nagamuthu sir is seen but not to be heard. But Prem, yeah, please, sir.
No democracy can afford to stifle the dissenters.
Absolutely no, sir.
And
But the issue was that it's stifling dissenters in what platform? When a doctors, there can be 100 of doctors, a patient is there. If a final decision has to be taken to treat that patient, you cannot, all the doctors cannot treat that patient saying that I got a right to dissent and I'll give this injunction. He'll say
Not that.
medicine.
The executive treating them with vengeance in their appointments and promotions.
I was throwing open another train of thoughts that was possible because you expect something from a system, and system is indulging in something entirely different, which gives a picture. I was only on that, not that. I mean, I fully concur with what Prem has said. I just wanted this.
Those great judges were able to foresee the true spirit of law in advance.
See,
I'll also request call sir. You have muted yourself. Yeah, please.
You see, Supreme Court is laying down the law, and it is laying down a policy decision. And if you don't have recorded dissent, people will be deprived of the other side of the view, which one can hold. Yeah. And this gives opportunity to the people to see that side and examine the correctness or otherwise or proper approach. That is how, when you look at these minority opinions or dissents, you find that Supreme Court had to change the course of events. And that is why today every judge, if you read what Justice Nariman said about Justice A.K. Gopalan's dissent, he said, it is a fresh air.
Yes.
How will you get this fresh air? You'll be deprived of this fresh air. If you don't have these judgments recorded in the law reports, and people have an opportunity to go through this. And then he says 3 great dissents.
Correct. Correct.
He does not say 3 dissents. He says 3 great dissents. And he says, I think it says A.K. Gopalan, Fazal Ali in A.K. Gopalan simply takes our breath away. And then he goes on to say what his opinion in that judgment was and how prophetic and how correct and visionary this judge was. So you see, you celebrate them. How do you celebrate Justice Khanna? Because you celebrate him for his minority opinion or dissent in ADM Jabalpur's case, which has, I think, not only been appreciated in India, but I think it is become almost a part of the Universal Declaration of Human Rights.
Even the British tabloid said that light at the end of the tunnel of
Yes.
the dark era.
So therefore, if you don't have, I cannot see trial courts. I'm not very particular about trial courts writing their dissents, but I think we should have those judgments which become binding on all of us and become the law of the country. We must know what is the other way of thinking about them. And at one point of time, we should be able to draw a balance and see which one is more enduring and which is going to keep your
audio problem.
Skeleton.
Audio is a bit
Sir, you have some audio problem. Voice is breaking.
Life in blood, flesh and blood, you know.
Exactly.
I don't have this internet today. I'm trying to use my mobile. But anyways, bony skeletons, after all, when you draw a constitution or you draw a legislation, it's a bony skeleton. You have to fill it with flesh and blood. Who fills it with flesh and blood? By judges who have that vision and who have that, knowledge about the subject and the mastery over the writings, that you find that it becomes one of the things which over the period of time evolves and becomes something which you feel proud of. I think that is very important. Let us not muzzle the dissent. Dissent is very integral to the democracy and rule of law. Thank you very much.
See, not only that, even in the legislature, when they are passing a law, when the minority, the opposition raises some valid points requiring some amendment in the law, if it goes to the select committee for the purpose of discussion, probably the minority, the dissenting opinion given by the minority legislatures were sometimes accepted and some amendments were being introduced. So
even in the making of the constitution.
Making of the law also. That is what I'm saying. So,
I heard Justice Joseph, Korean Joseph, saying after he left, left the office, he said he should not have agreed with the majority in NJAC case.
No, even some judges have said that the old death penalty case and rare cases given was not correct.
He has given a dissent outside.
Yeah.
So that is not going to help us.
No, that's not going to help. I am only saying it is better to write it there rather than to say it outside.
No, even in the judges case, what happened was all of them were commenting on the present system of a collegium system, and they want some change. But what is the change? How will it be done, etc., has not been made clear even in those judgments. That is the difficulty. Is left open to be discussed later by themselves or by the executive and the judiciary and the people. And to think about how this will be modified, etc. So that is how it has gone. So always dissenting, we can't say that dissenting is always bad. And also as far as judiciary is concerned, in the subordinate judiciary, there is no question of dissenting arrest because only one person
That's
has
what I said.
judgment.
Yeah.
And no, even in the High Court also, when it comes, we may have sometimes, Ramkumar and my judges may be knowing, we may have some dissent sometimes, and we will discuss and sort out and to have a consensus for the purpose of getting a clarity on the point. So sometimes that may also happen. That may be a reason why always dissenting judgments are not coming. That possibility you cannot rule out because there used to be a discussion among the benches.
And the art of surmounting binding judgment through the disingenuous process of distinguishing.
Yes.
Sir, we have somebody who had vociferously advocated freedom of speech and anonymity. Now she's coming forward, Sujita Subramaniam, to support Prema.
Well, hi, can you hear me?
Definitely.
Oh, yes.
Now we
Yeah,
can.
so, hello?
Yeah.
Yes.
Yeah.
Yeah, Prem, I think that was clearly a very good compilation, a very good talk. I thoroughly enjoyed, unfortunately, all the bits that I could hear because there were various technical issues. Because of which I missed quite a lot of your presentation, sadly. But I'm going to ask Shyam to send me a copy of the recording so I can actually listen to the whole thing, because I think there's quite a few notes I would like to take and check out some of, I mean, the main cases, of course, I have read them, but some of the other cases I would like to actually go through them. So, but thank you very much. That was really excellent. I just wanted to add a couple of points. One, to add to the bits that everyone else had spoken about as to why we need dissenting opinions. I think a good example of that is actually the groundbreaking legislation in the US, the Ledbetter versus Goodyear Tire case, where Lily Ledbetter had sued her employer for alleged discriminatory pay, where she had stated that she'd started with the same salary as her male co-workers, but by the end of her tenure in Goodyear Tires and Rubber Company, she was actually being paid lower than the others, the other men at her job. And when it had reached the Supreme Court, the case was being, the issue that they were looking at was whether or not she had filed her claim in a timely manner under the Civil Rights Act of 1964, which holds that employers cannot discriminate on the basis of gender and the Equal Pay Act. And the Civil Rights Act actually stated that they had to file the case within 180 days. And Justice Ginsburg was one of the key dissenting opinion. She wrote a fantastic opinion wherein she actually pointed out that if there is a worker will know immediately if you're not given a promotion or if you're being transferred, you know something has happened. But when it comes to compensation disparities, these are kind of often hidden from sight and you don't know about it immediately. So if you have a rule which says that you have to file the case within 180 days, this kind of provides a very cramped interpretation of the Civil Rights Act. And therefore it is quite unfair for the women because she's not able to claim for it. And this became kind of a battle cry of Ginsburg opinion, which was then taken up by President Obama in the 2009 Lilly Ledbetter Fair Pay Act, which amended the Civil Rights Act of 1964 to reset the statute of limitations on equal pay lawsuits. So basically what has happened is the dissenting judgment has acted as kind of like a lead for a particular legislation to be changed because they had pointed out some sort of a discrimination or problem in relation to that a particular legislation. So I think, of course, dissenting opinion becomes really, really important. Having said that, given that everyone has said nice things about Prem, can I add a small dissent? Prem, I just...
Sure, you are entitled to.
So, all I really would want to add is that I think it's nice of you to have pointed out, I mean, the three judgments, as you mentioned, Gopalan and Karak Singh and Jabalpur, where he had mentioned, of course, it's been recognized very widely as to why the dissenting opinion was a breath of fresh air. Whilst you had noted that Sabarimala, the Aadhar case, as well as the Chelameshwar case, also should be recognized, so on. What I would have liked to see in your analysis is as to two things. Why there is this dip in dissenting judgments, a pretty significant dip. I mean, there were a couple of suggestions that were already mentioned. wherein they said that it could be because of the compilation of the composition of the bench, how that is done, or maybe it's how judges are appointed in the Supreme Court, it being vague and opaque and so on and so forth. Maybe it's that what calls for this absolutely significant dip, and also an analysis of the specific judges who tend to be, like chronic dissenters maybe, or so on and so forth, to show how they have actually changed the pathway in terms of progressive rulings and so on and so forth. I would have liked to hear a little bit more analysis in relation to that. I could understand it's really difficult in a long talk of this nature, 1 hour, to bring all of that as well. But it doesn't take away from how wonderful your talk was. So thank you very much.
Thank you, Suchita. And Prem, on the lighter vein, I might say that to her last comment, wise men think alike, fools seldom differ.
No, I was actually, Sujita, I was mentioning about your lone voice. In my talk, I was mentioning about you and Justice Nagamuthu also. I was mentioning about you both.
No, I didn't. I was just, I think I take the contrary position always. So, I.
No, that sometimes gives the flavor.
So chronic, is it chronic?
I think so. I think we need that, isn't it, in order to.
Sometimes it may give flavor for the debate. That's all.
Nagamuthu sir, please join us. You'll have to unmute yourself, sir. So just unmute the audio. I have done from my end. Now it's for you to do. Yeah, please.
Yes.
Hello.
Good evening.
Good
Good
evening,
evening.
sir.
Good evening to all of you. This is Ram Kumar, Mr. Ramakrishnan, and all the others. And Mr. Prem, it was a wonderful lecture. Really, I missed it halfway through because I had to leave for the Supreme Court function.
Oh.
And again, I rushed back and I joined again. So I'll have the benefit of hearing you again in the YouTube. And one thing which I want to say as my concluding remark today is that Cochin is not the proper place for you to practice.
Right.
It's a high time that you should think of shifting yourself to the Supreme Court.
Prem, your days in Cochin are numbered.
Number.
Thank you so much.
We need to have lawyers like you in the Supreme Court and who are very bold, we are forthright, who are
You take him as a judge from the bar.
yes, we need people like you there
Absolutely.
to support at least old people like me in our fight for justice for the common man, more particularly the poor people of this country. We need people like you. Please think of that. This is the last remark I want to.
Probably an offer from Justice Nagamuthu.
He's not making this offer to me. I am in Delhi. He does not make this offer to me.
He's an youngster. He can be there for another 40, 50 years. Whereas what is our age? We can be there only for a few more years.
He'll be there for long years.
Yes. So it is high time. It is my wish that you are there. And I want to see you in action in the Supreme Court soon. So thank you.
As a judge from the bar.
Yes.
Thank you.
Thank you.
So much, sir. Thank you so much. Very wonderful.
Yes, Advocate Vishwanathan, sir, you have been showing your hand, please. Yeah.
Prem, you have done a marvelous work.
Thank
In
you.
this discussion. A simple doubt I have. Now, the majority decision of the Supreme Court is the law of our land.
Correct.
It is correct that the dissenting judgment has got a good role to play. But what we find the majority decision is executed or it is carried on. But the dissenting judgment is still held in the books. It takes a long time to come to the play. So there should be a mechanism to make this majority decisions and the important dissenting judgment to come to a conclusion and make a finality for the benefit of the common people. Is how we can find a mechanism for this. That is my
Very difficult.
Well, that's what I told you, because Article 145, Clause 5, that provides for the majority opinion is to be taken into consideration. Now, we have to amend the Constitution. There is no other provision. Or, later on, the judges, they themselves should take note of these dissents, and then they should go in line with those dissents. Otherwise, things are not going to be as good. It's not going to be so good. Because you remember the poem of Rabindranath Tagore, where the mind is without fear and the head is held high, where knowledge is free, where the world has not been broken up into fragments by the narrow domestic walls, where words come out from the depth of truth, where tireless striving stretches its arms towards the perfection, where the clear stream of reason has not lost its way into the dreary desert stand of dead habit, where the mind is led forward by thee into ever-widening thought and action into that heaven of freedom. My Father, let my country awake. Nothing more can I say. Nothing more.
In literature also, I think Prem excels now.
Definitely. And before we come to the conclusion of today's session, we have Sarita Premraj also with us. So let us see how far Prem allows dissent at home. Unmute yourself.
Is it on law?
I mean, everything for that matter. Let us see.
I am a great dissenter.
Sarita, please unmute if you can.
The very fact, if he doesn't unmute, that means the very fact that I am a lone crusader for justice.
Or she doesn't want to criticize you in open sometimes.
She dare not.
For all of us, we'll say bye after 5 minutes and it's rest is history. So let us leave it as that. So friends, that brings us to the end of the 85th session of legal empowerment through interaction. Empowerment, we have been getting empowerment like anything in the sense like wonderful session one after another. Tomorrow we have adoptions in India, history, practice and procedure by Justice Dias, Judge of the High Court of Kerala. Tomorrow 3:30 we'll meet again. Once again, Prem, thank you very much for this wonderful session, enlivening, enlightening and keeping the interest of all in our platform. Like we are thankful to, of course, Professor Kaul for introducing the topic subject being part of the deliberation, Justice Ramkumar, Justice Roshan Dalvi, Justice Shalini Joshi, Justice Ramkumar sir, Justice Nagamuthu sir, Justice Basant, and all of you. Thank you very much for being a part of this. And in spite of his busy schedule, we find that Ramachandran sir joins us every afternoon. Though he always says he's a latecomer, joins late, but the interest shown by him and forfeiting his afternoon sleep. Sir, thank you for the interest shown, and that gives us more inspiration to continue with the platform to make it even more interesting and useful to all of us. Thank you, everybody.
Thank you.
Tomorrow afternoon, 3:30.
In fact, I was arguing before a constitution bench, 8 judges.
Anyway, let us, but we didn't hear any sound of dissent today. That's not nice. We should have had some dissent today. Everybody was in some, but they cannot dissent today, Prem, because
there was a dissenter, Sujita.
Sujita, thank you. So thank you very much, and I hope everything is okay in UK, Liverpool especially.
It's fantastic here.
Wonderful. We'll send some corona over there. Till then, have fun. We'll meet again tomorrow afternoon 3:30. Thank you very much.